Thank you. Thank you very much. You have no idea as a lawyer how happy I am to get applause before I begin to speak. Okay, in the 8.5 hours we'll have together tonight, it'll only seem like 8.5 hours. I'm a lawyer after all. I'm going to turn you, each and every one of you, into mean, lean, legal machines. Each and every one of you will come away with a good understanding of the basic principles of law governing consent to treatment, counseling, and care in the province of Ontario. The principles that govern capacity to consent to treatment, counseling, and care. The circumstances in which one person can get legal authority to make treatment, counseling, and care decisions on behalf of another. And the safeguards that our law has in terms of substitute decision making. You're also going to understand the basic principles governing capacity to make financial decisions. The circumstances in which one person can get legal authority to make financial decisions on behalf of another person. And the safeguards in our law to protect your loving son, the one with the gambling addiction, from squandering what's left of your estate. Okay? Now, I'm going to divide the talk up into sub issues, and I'll talk, let's say, about consent, and then I'll ask you if you have any questions. I'll try to answer all the questions that all of you have, but depending on the amount of time we have, I might have to put some of those questions off. I will remain at the end of this session and try to answer any of your questions. Okay, you have to start this issue with understanding the fundamental role of consent to treatment, counseling, and care. Consent of the patient is at the core of all treatment, counseling, and care relationships. Why? Because our law puts a premium on autonomy of the individual, your right to control your body. And that's reflected throughout the law in this area. Now, one of the keys in this area is not to ask questions of consent globally. You know, did the patient consent? You have to ask specifically, who is giving consent to whom for what? Are you talking about a 14-year-old giving consent to a medical doctor for treatment? Are you talking about a 25-year-old giving consent to release information? So you have to ask the issues of consent precisely. And what we're going to review are the principles of law governing consent to treatment and other services under the Health Care Consent Act. This is the legislation that governs treatment that is provided by all regulated health practitioners: doctors, dentists, nurses, OTs, PTs, chiropodists, Methodists, Baptists. That's a joke, okay? Sorry. All right. So these are the general principles. So the fundamental principle in terms of consent is that a healthcare practitioner must be of the opinion that you are capable and of the opinion that you consented to the treatment, counseling, or care. Now, as I'm fond of saying, they don't have to be right. They only have to be of the opinion. This is like horseshoes. You get points for close. It doesn't matter what other people think. It doesn't matter if your kids think you're a dingbat. I think that's a psychiatric term. I'm not sure. If the healthcare practitioner is of the view that you are capable, then that is the authority that they need. So they must be of the opinion that you are capable and of the opinion that you consented. If they are of the opinion that you are not capable, then they must obtain the consent of a substitute decision maker. But you don't get to the issue of substitute consent until there's a finding of incapacity. Okay, so what are some of the elements of consent? And this is simple, right? The consent must relate to the treatment that is being provided. Duh! There's a great case. It's from Windsor. It's called Schweizer. I love Schweizer because it's such a dumb case. A guy goes into a hospital for an operation on his big toe and signs a consent form for an operation on his big toe. Now, for those of you not medically trained, it's down here. Unfortunately, the doctor fused his spine. That's over here. I guess the doctor's defense was the toe bone's connected to the foot bone's connected to the leg bone's connected to the... It didn't work. Okay, so the consent has to relate to the treatment or counseling or care that is provided. The consent can't be obtained by fraud or misrepresentation. Again, this is hardly a novel concept. The consent must be given voluntarily, but voluntarily in the legal sense, and that is the product of a conscious mind. So if I trip, my hand goes out, that's an involuntary act. But if the only reason you go to your doctor is because your boss is going to fire you, your consent is voluntary. If the only reason you go to your doctor is because your girlfriend or boyfriend is going to leave you, your consent is voluntary. If the only reason you go for treatment is because you're on parole or probation, your consent is voluntary. Now, why does our law do that? Because the law is of the view that what motivates you to come to treatment is your business. It is not up to a doctor or a nurse or healthcare practitioner to second guess why you choose to consent. And that is why voluntary is defined very, very narrowly. Okay, the next principle is the consent may be given implicitly or explicitly. Unless a statute provides otherwise, the consent must be given implicitly or explicitly. All kinds of agencies run around getting signed consents in many circumstances where they serve no function. Why do I go to my doctor's office? To read Time magazines that are 14 months old? No. The fact that I go to the office, the fact that when the doctor asks me a question, my lips move, is implied consent. And so the consent may be implied, implicit or explicit unless a statute requires a signed consent. Now, some statutes do require a signed consent for treatment, but those are few and far between. All right. Now, under the Healthcare Consent Act, the consent must be an informed consent. And the Act lays out what it means by informed consent. And the healthcare practitioner has an affirmative obligation to answer all of your questions openly and honestly. So if the patient asks a scary question like, is there any reason to believe that this marital counseling will save my marriage? You have to answer, no, but you'll be a happier divorced person. Because we know marriage counseling was invented by divorce lawyers to generate revenue. That's a joke, sort of, kind of, maybe, okay. All right, so all questions must be answered honestly and openly by the healthcare practitioner. The healthcare practitioner has an affirmative obligation, whether you ask a question or not, to give you information about the nature, benefits, risks and side effects of the proposed treatment. Whether you ask or not, the healthcare practitioner must give you information about the risks, benefits, and alternatives to the proposed treatment. The healthcare practitioner must also give you information about the likely consequences of not having the treatment. Now, this has been a good change in the law in that it now requires healthcare practitioners, when they propose something, to put the proposed treatment in the broader context of its alternatives and to put you in a position of making a truly informed choice. And it is an affirmative duty. You don't have to ask any questions. They have to do that if the consent is going to be valid. If the patient is capable, you need their consent and their consent alone. It is amazing how many healthcare practitioners run around getting everyone else's consent except the patient's. It doesn't matter what Uncle Fred's family think. You need the consent of the patient if the patient is capable. We don't have consent by democracy. Okay, how many people here think Bob needs liposuction? Raise your hands. We don't do it that way. If you're capable, you get to make the decision. And a capable person can withdraw consent at any time. So I'm going in for a gallbladder operation. It's April. The sun is shining. I am going golfing. I pack up and leave. So patients can make any decision they want as long as they are capable. Okay. The next thing that we're going to talk about is capacity. Are there any questions about consent generally before I go on? If there's one or two, I'll take them. If not, I will move on. Okay. Capacity to consent. For a consent to be valid, it must be given by someone who is capable. That's the language of the Healthcare Consent Act. Under the common law, the old common law principles, they talked about competency to consent. They're synonyms. They're synonyms. I sometimes use the word competency. The Act uses capacity. They mean the same thing. Okay. Our law defines capacity broadly. Is this patient now able? So a capacity assessment is a snapshot in time. Is this patient now able to understand the information relevant to making the treatment, counseling, or care decision in issue? And is this patient able to appreciate the reasonably foreseeable consequences of consenting or refusing consent? The test of capacity in our law is a very low threshold test. You may be young. You may be old. You may be developmentally delayed. You may be high. You may be intoxicated. You may be an involuntarily detained patient in a psychiatric facility, and yet you may be capable. The test of capacity looks at the ability to understand information. It is not based on the ability to make a wise or prudent or rational decision. Now, why does our law do that? To maximize the autonomy of the individual. The difficulty is autonomy is a double-edged sword. It allows you to make brilliant decisions. It allows me to make dumb decisions. And the fact that the decision is unwise, imprudent, doesn't affect capacity. So a very, very low threshold test of capacity in our society. Again, reinforcing the fundamental importance of the issue of autonomy and your right to control your own body. All right. I want to briefly talk about two cases. The first case is a case called Re-C. In Re-C, you had a 68-year-old man who had suffered from paranoid schizophrenia for most of his life. And he had been involuntarily detained in a psychiatric facility for much of his life. He develops gangrene in his foot. And the doctors indicate that unless his foot is amputated, he has a 15% chance of survival. They do not believe that he is capable of making that decision. And he goes to court, he applies to the court, and he asks the court for a declaration prohibiting the hospital from amputating his foot without his consent. And what the court said is, I have to now determine whether this man's cognitive ability is so affected by his paranoia that he is incapable of understanding and appreciating the information relevant to the treatment. And the court said, while his general ability to make decisions has been adversely affected by his mental illness, he understood the information about the amputation. He understood the consequences of not having it. He came to a firm decision not to have his foot amputated. And therefore he was capable. And again, it illustrates the fact that capacity is a test that relates to processing information. It doesn't go to what you and I would consider. Now, that doesn't mean healthcare professionals shouldn't worry about wise and prudent decisions, right? And as one of the things that I tell healthcare professionals, it is really critically important to have a good relationship with your patients, to establish a relationship of trust with your patients, to encourage, support, and help your patients make wiser, safer, better decisions. That's the function of good communication skills. But when push comes to shove, the decision is the decision of the patients. The decision is the decision of the patients. It is not up to the courts to second guess what motivates you. It's not up to the courts to tell you what should be done with your body if you are capable. Bartosak. Bartosak is a case that is going to become of increasing importance. She was a 78-year-old widow who lived at home. She was hard of hearing and didn't have hearing aids. She had osteoporosis and used a walker. She fell in her home but got herself to the hospital. In the hospital, the social worker did an assessment and concluded that she was not capable of making decisions about whether to live on her own and placed her in a care facility. She challenged that decision to the Consent and Capacity Board, and they upheld the decision on the basis that even though she could understand the information, in the Consent and Capacity Board's view, she wasn't able to appreciate the foreseeable consequences of her decision, held her to be incapable. She appealed that decision to the court. And the court said very, very clearly that people can make a choice to live at home with risk. And the fact that the family viewed the decision as unwise is not relevant to the issue of whether or not she was capable. And it concluded she understood the risks of living at home. She understood that she would probably be safer in a long-term care home, but she chose to live at home with risk. My mother was in a wheelchair. She lived on her own. My mother made it clear to me on many occasions that if I tried to put her in a retirement home, she'd poison me. She wasn't kidding. And we tried to do whatever we could to provide assistance. So we got her to wear one of those lifelines, right? And we got community care access to come into the house twice a week. But my mother was of the view, when community care access came, she got up early and cleaned the house and made her bed, because no one was going to come to her house if her bed was unmade and her house was on. And it is quite clear that the courts are not going to displace individuals' rights to make those decisions in the absence of clear evidence of incapacity. And again, you have to understand the law's role is to set minimum standards. It doesn't mean that you don't work or encourage people to make wiser, safer decisions. But at the end of the day, those decisions are yours. Our law starts from the presumption that everyone is capable. Whether you're old, whether you're young, whether you have a mental illness, whether you're an involuntary patient, you start from the presumption of capacity, and you need strong and compelling evidence to dispel that presumption. Okay, so let us assume that a healthcare professional is of the opinion that you are not capable, explains to you that they're going to have to get the consent of your substitute decision maker. What are your rights on being found to be incapable? First, a healthcare practitioner, upon finding you to be incapable, has to explain to you the significance of that and the fact that you have a right to challenge that decision. Okay, so they explain that to you. You have a right to challenge the healthcare professional's decision to the Consent and Capacity Board. It usually meets within a week or two. It actually is an administrative tribunal that works fairly quickly. And let's say the Consent and Capacity Board agrees with your healthcare practitioner that you are not capable, you have a right to challenge that decision to the courts. When you indicate you're going to challenge a decision to the Consent and Capacity Board or the courts, no treatment or care can be provided except in an emergency to preserve life and limb. Okay? So nothing can be done until it's resolved. Now that's a real problem because the Consent and Capacity Board can meet and make a decision within 2 weeks. And our courts are not speedy in addressing these issues. And the problem is that we have people sitting in scarce beds in facilities with people on waiting lists, and if they challenge, nothing can be done until it's resolved by the courts. I'm not a big fan of using the courts, right? Because they don't work. That's the simple fact. If you don't believe me, go to any criminal court of your choice. So there are real problems, and I would prefer to see an administrative process for challenging, so that these issues can be resolved more quickly. But whether I like it or not, that is the current state of the law. Now, even if you are found to be incapable, you have one further right. And that is, if I'm 16 and incapable, I can ask the Consent and Capacity Board to appoint my brother. My brother Fred has always looked after me, so I'd like him to make decisions for me, okay? To become my personal representative. Now, the Consent and Capacity Board can consent or not consent to that appointment. But it still gives people who are incapable some control. A third person can apply to the Consent and Capacity Board and ask the Consent and Capacity Board to be appointed personal representative. So if you, my brother, apply to the Consent and Capacity Board, they can appoint you. But they will not appoint you if I object. Okay? So even on a finding of incapacity, you must be informed of its significance. You can appeal it to the Consent and Capacity Board. You can appeal it to the courts. Even if you are incapable, you can ask the courts to appoint a person of your choosing to make decisions on your behalf. All right. Any questions so far? Consent and capacity, going once, going twice. Yes?
In the case of Reese, he had 15% chance of survival.
Right.
If it was a 0% chance of survival, is he then charged with attempting suicide?
No. Okay, stop. There is no criminal offense of attempting suicide. There used to be an offense of attempting suicide, but it was removed. And here's the problem. I'm a Jehovah's Witness. You tell me, if I don't give you blood, you'll die. And my response is, I'd rather die than be damned to an eternity in hell. To which you say, got any proof? That is why the courts are not about to begin to say, the basis of your decision, and begin to assess the wisdom. And that's why communication and establishing a relationship of trust. I tell healthcare professionals, they have to use, their abundant diplomatic and communication skills. Diplomacy, advanced diplomacy, whining, bluffing, cajoling, advanced whining, bluffing, and cajoling. My wife's family doc was a family doc in London. She had a lot of older patients. She spent a lot of time encouraging them to go into hospital when they got sick so they wouldn't get really, really sick and have to be brought into the hospital for much longer time. And that's the way it should be. That's the way it should be. And so that's why, even if the chances were 0, once he said, I understand I can die, he's capable. Now, I'd like a concept of diminished capacity. In England, there's a concept of diminished capacity for people who are capable but vulnerable. Young people, those in mental institutions, or who have significant psychiatric problems, and some seniors who are capable but vulnerable to exploitation. But we don't have that concept, unfortunately, in Ontario. And it's exactly for that reason. Okay, yes?
What if in the case it's an extreme where emergency as far as health?
Okay, so the question is, What happens in an emergency? Now, both under the common law, that was the old principles, and under the Healthcare Consent Act, in an unforeseen emergency where it is not possible to obtain consent or a refusal of consent, healthcare practitioners are permitted to intervene to save the life and preserve the health of the patient without consent. And that probably applies to everyone in this room. So if you hear screams coming from your neighbor, you hop the fence, there's a kid drowning in the pool, you drag the kid out of the pool and you begin CPR, our courts are going to bend over backwards to protect you. And our courts have always bent over backwards to protect anyone who acts in an altruistic. You know, I've had people say, I don't want to stop at the scene of an accident and provide assistance. Doctors and nurses have said that, because I can be sued. Yes, you could be sued, but in fact, you could also be hit by lightning. Statistically, your chance of being hit by lightning are better than your chance of being sued, because there's only one case in Canada in which any healthcare professional has ever been sued, let alone held liable. And when the court stopped laughing, it dismissed the claim. So our courts are very supportive of anyone who acts in an altruistic fashion. Now, the reason you don't stop at the scene of an accident in California is because you're going to be shot. It's a crazy country. And if you don't believe me, go to Detroit unarmed. Okay, I'm joking, sort of, kind of, maybe. All right, moving right along. Okay, substitute consent. And people say this to me all the time. Well, who's the custodial parent? Who's the non-custodial parent? Who cares? The kid is 42. You don't get to substitute consent until there's a finding of incapacity. And people will come and say, I'm the power of attorney for Uncle Fred. Only to be told, he's got way more neurons on deck than you do. He's competent. I don't care. Okay, so you don't get to substitute consent until there's a finding of incapacity, or unless there's a statute that gives statutory authority. Now, there are some statutes that give statutory authority to people to make decisions. So in order to do IQ and personality testing under the Education Act of Ontario, you need the consent of the parent in writing. But those circumstances are very, very rare. Basically, you don't get to the issue of substitute consent until there's a finding of incapacity. All right. Now, substitute decision makers do not get a free hand to do whatever they want. The law is very clear. Any substitute decision maker is bound by the prior express wish of the incapable person if that wish was expressed when the person was 16 or older and capable. And capable. I'm not a Jehovah's Witness, so if I need blood, please give it to me. If I'm a Jehovah's Witness and I've told my wife that I don't want blood if I'm in a car crash and need blood, and I'm hit by a bus and taken to the hospital, and I'm not capable of giving consent, she must exercise consent or refusal of consent consistent with my prior expressed wish. Now, we'll talk about how that wish has to be expressed in a minute or two. But I'll take the question. Yes?
Is there any duty on a hospital, say in the case of a patient with brain cancer, and their spouse has power of attorney? Does the hospital have to see the power of attorney document to find out the person's expressed wishes?
Okay. So the question is, I have a brain tumor. And I am incapable, because if the husband has a brain tumor and is capable, guess what? He gets to make the decision.
No, but
Assume he is not capable. They are allowed, and the Act is very clear, to act on what they reasonably believe is a valid exercise of consent or substitute consent. Now, if it is quite clear they know the family, right? They know this person is the wife. They know that the wife is the decision maker. The guy told them before his last became very, very ill that he has a power of attorney. Then that's fine. If you're not sure, or there's something wonky about it, then yes, they can ask to see the power of attorney. So they don't have a duty to do it. They are allowed to act on reasonable appearances.
I can understand that they know that so-and-so is the actual substitute decision maker. My question is more directed to is that decision maker following the instructions of the person?
It is not, they don't have an affirmative duty to check to make sure that the decision is in fact expressed in the power of attorney. We'll get to these issues in a little while. They're allowed to act. Now, if you knowingly make a false statement as a substitute decision maker, that is a provincial offense. But the act is very clear. If I honestly and reasonably act on what I believe to be a valid consent or a valid substitute consent, I am protected from liability. So the answer is no, I don't have to check. It's not up to me to check. And also, you've got a problem, right? You've got this grieving wife, right? Her husband is dying, and you say, he told me X, Y, or Z, it's in the power of attorney, and you put your arm around them and said, you could be a lying son of a bitch. So there are problems. And again, so the law does not impose that affirmative duty. All right. A substitute decision maker is entitled to all of the same information that the patient would be entitled to if the patient was capable. Okay? Basically, just like the patient must be put in the position of making an informed consent, so does the substitute decision maker. Has to be put in the position of making an informed decision. All the same principles apply. Okay, now there are some safeguards on substitute decision making. A healthcare practitioner may challenge a substitute decision of a substitute decision maker if they have reason to believe it is not consistent.
Would the owner of the car parked in the roundabout, license number BPPM 795, moved immediately? You are blocking traffic.
Okay. If a healthcare practitioner has reason to believe that the substitute decision maker is not complying with the act, I'm sorry, I skipped a bit. First, you have to make the decision based on any prior express wish that is known, that is relevant by a person who's 16 and capable. If no such wish is known or relevant, you must exercise substitute consent in the best interests of the incapable person. Now, best interest is defined broadly, and the substitute decision maker must take into account the values and beliefs that the incapable person held when capable, any wishes expressed by the incapable person that are relevant when they were under the age of 16 or incapable. They must also take into account a series of 3 basically medical or treatment issues. One of which is this decision consistent with the well-being of the patient? And the courts have defined well-being to include quality of life. Quality of life. Okay? So, I must exercise substitute consent consistent with any prior expressed relevant wish, expressed when you were 16 and capable. If no such wish is known, I must exercise substitute consent in your best interest. Best interest includes not only medical criteria, but also your values and beliefs that you held while you were capable. All right. Safeguards on substitute decision making for personal care. A healthcare provider can challenge the validity of any substitute decision to the Consent and Capacity Board on the basis that it is not consistent with the Act. I'll give you an example. You and I are Jehovah's Witnesses. We have a 5-year-old child. The child is in a car accident. They have a ruptured spleen. They need blood. Now, clearly, the 5-year-old cannot consent. They need our consent. We refuse that consent. Now, obviously, the child didn't have a prior express wish when 16 and capable. So our decision can be challenged by the doctor if the doctor is of the view it is not in the best interest of the child, and will challenge and that decision will then be not accepted. And the child will either be made a temporary ward of Children's Aid, and they'll give consent for the procedure. And those kinds of things do happen. So to get back to your question, if they don't think that the decision is consistent with the first two general principles, they can challenge it to the Consent and Capacity Board. Okay? But they don't have a duty to second guess. If someone tells them and there's no reason not to believe them, then they have no obligation to investigate either who the person is or what wishes you had.
So would you recommend people put their prior expressed wishes in their hospital health records?
You probably can't put your prior expressed wishes in the health record because the health record belongs to the hospital, not you. I'll chat about ways in which you can try to make sure that your decisions that you want are followed. Yes?
When I was 19,
Sorry?
when I was 19, my...
2 years ago, right?
Yes.
Okay.
Thank you. My father told me that when he died, because he was thinking it was going to be soon, that he didn't want to be buried. He wanted to be cremated.
Okay. One of the things you have to understand, this deals with decisions while you're alive.
They were alive.
Once you die, doesn't matter if you have a power of attorney, it's of no force and effect. Upon death, the executor of your estate,
What if there isn't one?
then you die intestate, and there are certain rules about how the estate is then to be divided, and people can apply, I think it is to apply to the court to become the executor. And of course, you have to understand that in these kinds of family matters, there's been a recent study of Canadian families, and there are two kinds of Canadian families: dysfunctional and very dysfunctional. Thank you. Thank you very much. Thank you. Thank you. Thank you. Many of you are aware that the purpose of family law is to maximize the trauma to each and every member of the family and transfer as much of the limited resources of the family into the undeserving pockets of lawyers. Once you understand the true purpose of family law, you realize how brilliantly it works. Okay. We'll talk about that. And we'll talk about why it is a good idea for you to take control of your destiny clearly. Because while our law does provide ways of resolving disputes, they are slow, costly, acrimonious, and you want not to go there. You don't want your issue to go to law land, because everyone's meter is ticking at $400 an hour, and it is morale destroying. Right? I always say the other purpose of family law is to make criminal law look happy by comparison. Okay, so that's why it's really important to take control of your destiny. All right. If the office of the public guardian and trustee believes that an incapable person is at risk of serious illness or injury or a serious deprivation of liberty, they must investigate the matter. And if they conclude that the harm is occurring, they must apply to the court to become the temporary guardian of the person. Now that sounds great, except there's one problem. The PGT will not investigate until there is a formal finding of incapacity. That costs $800 to $1,200. So there's a safeguard. The healthcare professional can apply to the Consent and Capacity Board. And we know doctors just love to enter into that quagmire. And you can contact the Office of the Public Guardian and Trustee, but you need a certificate of incapacity. You need an assessment done. So that's not exactly cheap and easy. Alternatively, anyone may apply to the courts to challenge any decision made by a guardian or power of attorney. But when you apply to the courts, you'll have a lawyer. The incapable person will have a lawyer. The substitute decision maker who made the decision will have a lawyer. And, you know, life is short and then you die. And so there are safeguards on substitute decision making for personal care, but they're not easy breezy, and they're not cheap, and they're not quick. Okay. And that's why I think it's really, really important to have clear direction. Okay. Now I want to talk about an issue. It's in the legislation, it's called an advance directive. And our political masters decided to create this legislation. Okay. Anyone can make an advance directive orally or in writing in terms of how they want to be treated when they become incapable. Now, in the law, it's called an advance directive in the Act. It is sometimes called a living will, sometimes called a prior expressed wish. The difficulty is, be careful what you wish for. Because that prior expressed wish is binding on any subsequent decision maker. I don't want to be kept alive by heroic measures. What does that mean? You don't want Superman as part of the operating team? I never want to be kept alive by artificial means. Yes, you do. What you really mean is, if I'm not going to regain consciousness, I don't want to be kept alive. But if you have an open compound fracture of your leg and you're taken to the OR and you need to be given oxygen for them and an anesthetic while they fix your leg, because 3 months from now you'll be up, pole vaulting again. Be careful what you wish for. People wish for all kinds of crazy stuff. And the problem is, that is binding on any subsequent decision maker. Now, I have a couple of problems. There doesn't need to be any proof that you actually made the statement. Other than your brother, the beneficiary under your will, saying, oh yeah, he wanted to die with dignity. Yep, told me just this morning. I live in mortal fear that I'll get hit by a bus, I'll be taken to the OR. I'll have a ruptured spleen, it's an optional organ, right? You don't need them, right? A doctor will call my wife and say, Bob's been hit by a bus, he's got a ruptured spleen. We take out a spleen, we'll give him some blood, he'll live for 30 years. And she goes, We own the house jointly. I'm the beneficiary under his pension. No, Bob wants to die with dignity. And the surgeon says, look, if we give him blood and take out his spleen, he'll live another 20 years. To which he says, my point exactly. She's a cruel but perceptive woman. And by the way, he likes the pillow fluffed up on top of his face. There doesn't have to be any proof that the statement was ever made. Nor does there have to be any proof that when I made the statement I was capable. Why? Because we presume everyone is capable. This is way too loosey-goosey for me. The legislation, in an effort to protect patient rights, threw out baby with bathwater. And I worry about circumstances in which people make rash statements, without thinking about the implications in crisis circumstances, and they will govern forever. I worry about overzealous relatives, let alone the greedy relative. The vast majority of abuse against seniors is financial. The vast majority is perpetrated by family. So I don't like this. That's way too loosey-goosey for me. And I think that that's a real problem in the legislation. All right. Now, I'm now going to talk about the 5 ways in which one person... Yes?
I just wondered when you said that. I just did mine.
What, an advance directive?
Yes.
Okay.
In my car, but
Okay, okay, we got to stop. All right, okay. An advance directive can be anything from an oral statement to a written statement, okay? Now, I'm not opposed to advance directives. I think they should be in writing. I think you should think about what it is you put in that statement, because as I said before, people say all kinds of things which they don't really mean. And you could file that with your family and talk to your family about it. File it with your lawyer and your family doc. So that will give you a measure of protection. The problem is, what I worry about is somebody is clearly psychotic. So they're detained under the Mental Health Act. They're not capable of making decisions about whether or not they want antipsychotic medication. They go to the substitute decision maker, and the substitute decision maker says, my brother told me he didn't want antipsychotic medication 5 years ago. That's binding. That's binding. How is a psychiatrist going to challenge that statement? And the psychiatrist may have views that the guy wasn't capable when he said it, but it doesn't matter. He's presumed to be capable. Try to prove retroactively that someone wasn't capable. So it's way too loosey-goosey for me.
That should be illegal itself.
Sorry?
That should be illegal itself.
Well, that's if I knowingly make a false statement, it is illegal. But if I express the view of the incapable person, it's binding. Anyway, we gotta move on, and we'll never finish. Okay, there's 5 ways in which one person gets authority to make treatment decisions on behalf of another. The first is I go to court and ask the court to appoint me as a court-appointed guardian of the person. Now, a court will not appoint a guardian unless they are convinced that the person is incapable, so you need formal assessments. Okay? 2, they won't make a guardianship order unless decisions have to be made. They won't make a guardianship order if there is some less drastic means of protecting the incapable person's interests. Now, where do you get, when is a guardianship order generally applied for? I have a child. The child has profound developmental delays. The child needs lots of treatment. They're not capable now. They won't be capable 5 years from now. They won't be capable 20 years from now. So I want ongoing authority to make treatment and care decisions for my child. Or I'm hit by a bus. I have an acquired brain injury. I'm not going to be able to make decisions for the next 20 years of my life. My wife will go to court to become a court-appointed guardian because it gives ongoing authority to make decisions. And a guardianship order gives authority until a court revokes it. And when we talk about powers of attorney, you'll understand why that's important. Because the power of attorney does not give any authority to make decisions until there's a finding of incapacity. Whereas a court-appointed guardian, the courts have adjudicated the matter, ongoing authority. So the guardianship order may be full or partial. The court will make as limited a guardianship order as possible to preserve whatever decision-making ability the incapable person has. So the first and highest in the hierarchy of decision makers is a court-appointed guardian. Okay, you're my power of attorney for personal care. Okay, I've executed it fine and dandy. Your sister, right, thinks you're not acting in my best interest. She can apply to the court to become a court-appointed guardian to displace you. So that's the highest person on the hierarchy. The second way in which a person gets authority to make decisions on another person's behalf is a power of attorney for personal care. A power of attorney for personal care. A power of attorney for personal care is a formal legal document. It has to be witnessed by 2 individuals, and there are rules about who can and can't be witnesses. And a power of attorney, in order to create a power of attorney, I must be 16 and capable. In order to serve as a power of attorney, I must be 16 and capable. Now, a power of attorney gives you broader abilities than an advance directive. An advance directive allows you to dictate what treatment you want. But in a power of attorney, you cannot first dictate what treatment you want, who you want to exercise that authority, and how you want your capacity to be assessed. An advance directive, because they're so loosey-goosey, are relatively easy to challenge. Formal powers of attorney are much more difficult to challenge because you generally get one in the presence of a lawyer who can attest to your capacity. In the presence of 2 witnesses who can attest to your capacity. And so it's much harder to challenge a power of attorney than an advance directive, and it gives you broader authority. It gives you broader authority to choose. Now, you can choose whoever you want to be your power of attorney. I've chosen Barack, the Queen, and the Pope. In Ontario, you're not required to tell the people who... Yes, it is stupid. It is that stupid. So you can choose whoever you want. However, the power of attorney who you've selected can only actually exercise it if they are willing, capable, 16, and available. Up until last year, we had one kid, one of our children was in Uganda, the other was in Brisbane. It wouldn't be wise for us to make those two children our power of attorney because they weren't available. Now, this is the other thing that you have to be aware of, and a lot of people aren't aware of it. If any two people on the same level of decision-making disagree, they don't get to make the decision. The PGT does, Public Guardian and Trustee. So if you name all 22 of your children as your power of attorney, and they disagree, none of them will make the decision. It may be wiser for you to appoint one of your children as your power of attorney, and if they are not available or willing or capable, an alternate. But if you name them all equal and they disagree, they don't get to make the decision. They don't get to make the decision. Now, if I am a court-appointed guardian, upon the completion of the guardianship order, that gives me ongoing authority to make any decision that is subject to the guardianship order. If I have a power of attorney, it gives me zero authority until such time as a healthcare professional says, I am of the opinion that you are not capable, and you don't challenge it. That's the benefit of a guardianship order. And that's why people get them when they want ongoing authority, because they don't want to have, every time there is an issue, to have the incapable person challenging, second-guessing, etc., etc., etc. The guardianship order gives, okay. A power of attorney only begins once there is a finding of incapacity that is not challenged. And that's why when the son comes in waiving the power of attorney, it's irrelevant. If Dad is capable, Dad makes the decision. Gives no authority. One of the major problems I have is that many people don't understand this stuff. And I think the government is largely at fault because, amidst arbicide, the unwarranted killing of trees to produce government propaganda of questionable accuracy, they never explained this to people. They talked about patient rights, but they never actually explained. Now, there are two actually wonderful websites. One is the Consent and Capacity Board has a wonderful website with really good public legal education materials. Excellent. I'm surprised. And the other is the Office of the Public Guardian and Trustee. And they have really good materials that lay all of this out in lay language. Clearly it wasn't written by a lawyer. Otherwise it would be unintelligible to carbon-based life forms. Okay. All right. So, let's say you don't have a court-appointed guardian. Oh, by the way, a power of attorney provides authority if you are incapable until the incapable person dies, then it's the executor. The guardian, the power of attorney dies. The power of attorney is revoked in the same form in which it was created, or the power of attorney has been superseded by a court-appointed guardian. Okay? So, if you have a power of attorney, right, and you forget about it and express a wish, power of attorney is going to govern. Power of attorney is going to govern. All right. So let's say you don't have a court-appointed guardian. Let's say you don't have a power of attorney. Who's next? A personal representative. Right? Remember, if I'm incapable, I can ask the Consent and Capacity Board to name my sister to make my decisions, or my sister can apply to them to be my personal representative to make my decisions. Okay? So even if I have a spouse, if I have a personal representative ranks ahead, etc. Now under Section 20, there's then a host of relatives. So I don't have a court-appointed guardian, I don't have power of attorney, I don't have a personal representative. Then you go to that list, and the first person on that list is a spouse, which is basically anyone in a conjugal relationship of any kind. Okay? Or partner. Partners are people who've lived together in a meaningful relationship. Clearly it doesn't apply to marriage. That's a joke, sort of, kind of, maybe. Okay. Okay. Partners are people who are not in a conjugal relationship, but have lived together in close. Two widowed sisters who live together would be partners. Okay? They would be partners. Now, the good thing is, when a couple separates and lives separate and apart, even if they're not divorced, they're no longer spouses. Fred, my former boyfriend, yeah, he wanted to die in agony, okay? He wanted to die in agony. None of this dignity. He wanted to die in pain, okay? So salt on all the wounds, salt on all. So former spouses who live separate and apart are not spouses under the Act. Okay, so if I don't have a partner or spouse, it's then parent or child. Parent or child. Okay? If I don't got a parent or child, it is then a sibling. If I don't got a sibling, then it's any relative by blood, marriage, or adoption. And if I'm truly desperate and dateless, it's the office of the public guardian and trustee. Better you are not in the tender hands of the office of the public guardian and trustee. They're slow and they're conservative, and you know, I wouldn't want to end up in the hands of the office of the public guardian and trustee. All right. Any questions? We're a little behind, and so if it's all right with you, I'll probably go on a little past 8:30. But they're great questions, and I want to answer them. So I'm willing to take them as long as you understand. You know, we may not be done till 12. Oh, sorry. Yes. Yes.
In terms of power of attorney, the terminology I've seen used is two people jointly or severally, and I know there's some problems using that, but I think it's used, you know, in case one's not available, you don't want to say jointly.
Yeah, if you say jointly and they disagree, PGT.
If you say jointly or severally, then...
Severally, the difficulty will be, well, the difficulty will be if it comes to a situation where your daughter says no treatment and your son says treatment, and they're appointed jointly, PGT will make the decision. So, any other questions? Yes, sir.
I have one question here, something you said here. If I'm taken to ER for something, and then released, and I would like to have a copy of the medical report from the hospital or family doctor, I'm denied.
Sorry?
Why can I not get a copy of my medical record from the ER?
Why you can't get what?
A copy.
Yes, you can. Okay, so
Or family doctor report.
Okay. This is a completely different issue, and it deals with the patient's right to access.
Yes.
Okay? At common law, our court, a case called McKinney and McDonald, 9-0, that's a shutout, doesn't get any better than that a patient has a prima facie right of access to any medical record, or any record that a healthcare professional has about them, unless they can prove disclosure would pose a significant risk of harm. And I think one of the problems is that people don't understand their rights. And so they contact the hospital says, nope. And at a certain point, the law says you're entitled to that information. Okay? Now, I don't want to get into the complexity of these issues. Under the Personal Health Information Protection Act, your right of access is in fact narrower than the common law. But that act didn't displace the common law, and therefore the common law still applies. It's a complicated issue. We're going to have to wait till it gets to the court. But the basic rule is, I go to my doctor, I am entitled to a reasonable right of access to my record. Now, I can't come by at 4:45 on Friday and say, hi, I'd like a copy of my record in a room with a shredder, please. I'd like to take my record home for the weekend, you know, where I can buy some whiteout. So it's a reasonable right of access. But what that means, according to the Supreme Court of Canada, is you can get a copy and they can charge on a cost recovery basis. They cannot hire a team of monks to handwrite it and charge you $8 million a page. Only $4 million a page. Yes?
Yes. If you have power of attorney separately, severally,
Okay.
okay, and if there's a dispute, can you write on your power of attorney that if there should be a dispute, you want this person's
Yeah, yeah.
or a different person's
Or whoever wins the Super Bowl.
somebody else's?
Yes, yes, you can put all kinds of silly stuff in your powers of attorney. Now, you can put in your power of attorney virtually the way in which you want capacity to be assessed. You have to understand this legislation was written, driven by patient rights rhetoric. And once you wrap something in the concept of rights and rights rhetoric, you know, no longer does it have to make any sense or be useful. Like the advanced directive stuff, which is terrible, in my view. But doesn't matter. Yes, last question before I go on. Yep.
Dealing with capacity, someone who their first language is not English, and
Right.
with English, if they sign like a legal document, power of attorney, maybe not with a lawyer, but written up, and obviously it's easy to write it in English because anybody you're going to show it to, and they're going to be speaking English.
Right.
Is that going to be questions that they understood?
Okay. And this is what hospitals don't understand and doctors don't understand about consent forms, and what a lot of people don't understand. The issue for the court is not, did the client drag their hand across a piece of paper? The issue for the court is, did this person sign this document understanding its legal implication? There's a great case called Barbalov. The guy goes to his lawyer to make out a will. So while he's there with his son, the son has a clever idea. Why not get a power of attorney? Well, Dad didn't read English, and the son sort of kind of explained the power of attorney to him, and he signed it. Then Dad became incompetent. There was information about the treatment that he wanted in the form, and it was challenged and it was overturned, and the court said it doesn't matter if he signed it. The issue is, did he understand the legal significance of that document? And given that he didn't go to the lawyer's office to do a power of attorney, given that he didn't read the document, given that the son sort of kind of to making this financial decision, and are they able to appreciate the reasonably foreseeable consequences of making this financial decision? And just like capacity to consent to treatment relates to the ability to understand information and not the wisdom of the decision, so too does capacity for property relate to the ability to understand the information. Ronnie Hawkins is alleged to have said, "I made millions of dollars. I spent 80% of it on drugs, alcohol, and women. The rest I wasted." It may be the only profound thing that Ronnie Hawkins ever said, but the fact that you and I would view the decision as unwise. And again, why do we do that? To maximize the autonomy of the individual. You have to understand that the law sets the minimum standard. And that doesn't mean that healthcare professionals shouldn't use good communication skills, their relationship of trust, to encourage, support, and help people make wiser, safer decisions. And I often say that good communication skills is by far the most effective way of avoiding legal grief. Okay. So, now, a person has a right to challenge a finding of incapacity to manage property to the Consent and Capacity Board. Okay? Now, that's fairly expeditious. They meet within a couple of weeks. In Koch, the court specifically said, patients can spend money foolishly and choose to live with risk. Compelling evidence is required to dispel the presumption of capacity. And again, it's a low threshold test, deals with ability to process. There are safeguards. They can challenge the decision to the CCB. That's fairly effective. They can make a complaint to the PGT. But the PGT will only investigate if there is a formal assessment that has found them to be incapable, $800 to $1,200 later, etc., and you can apply to the courts. So I don't think the PGT, that right to apply to the PGT or to the courts, is user-friendly. It is certainly not fast, and it is certainly not cheap. All right. There are 5 ways in which one person gets legal authority to make property decisions or financial decisions on behalf of another. The first, I go to court and ask the court to appoint me to be a court-appointed guardian of property. Again, there must be a formal assessment of incapacity. You have to convince the court that the person is in fact incapable of managing their assets. And again, once you have that, that provides ongoing authority to make financial decisions. Now, many of you have already probably signed a document that gives your stockbroker the right to sell and buy shares on your behalf and to manage your stock portfolio of $14.30. Okay. Now, there is a power of attorney under the old Powers of Attorney Act. Before the Substitute Decisions Act was enacted in 1995, there was an old Powers of Attorney Act. And so those old powers of attorney continue in force. Okay? The third way is called a continuing power of attorney for property management. Now, to be a power of attorney for property management, or a substitute decision maker of any kind for property, you must be 18 and capable of making financial decisions. For personal care, it's 16 and capable of making personal care decisions. Okay, so for me to execute an effective power of attorney for property, I have to be 18 and capable. To serve as a power of attorney for property, I have to be 18 and capable. Now, here's something that is of concern. A power of attorney for personal care is of no force until a healthcare professional has found you to be incapable and you do not object. A continuing power of attorney for property gives authority to make financial decisions when signed, unless you provide otherwise. That's right. So unless you want your son with a gambling addiction to have equal authority in terms of your pension, your house, your assets, make sure your power of attorney says it only comes into force upon a finding of incapacity. Because otherwise, a continuing power of attorney gives legal power upon being signed. All right. Now, I won't go through this in a lot of detail. If you go into a psychiatric facility, now there is an obligation for your capacity to manage property to be assessed. And if there is a finding that you are incapable of managing your making financial decisions, the PGT, the public guardian trustee, will become your statutory guardian of property. Now that's good, because what used to happen is you have a significant psychiatric disorder, you go into a psychiatric facility, and you don't pay your heat, you don't pay your gas, you don't pay your taxes, and all of your assets end up being lost. And so that's good, so that people who have mental illness don't end up, living in the community and having whatever assets they had dissipated because they were not able to manage. So that's good. Okay. Now, I can request to be assessed in terms of my ability to manage property. A third person can ask to have my ability to manage property assessed. If the assessor concludes that I am not capable, they must issue a certificate of incapacity and inform the PGT. And the PGT will become the statutory guardian of property. So that's the fourth way in which someone gets control. I go into a psychiatric facility, I'm found not to be capable, the PGT has made my statutory guardian of property. I have an assessment done, I'm not capable of managing. The certificate has to be filed with the PGT. The PGT will become my statutory guardian. So that's the fourth way. Now, let's say I'm found not to be capable of managing my property, and the PGT becomes my statutory guardian. If I have a power of attorney for financial management, my PGT can apply, my power of attorney can apply to the public guardian and trustee to replace the public guardian and trustee. So if I go into a psychiatric facility, I'm found not to be capable, the public guardian trustee will become my temporary guardian of property. My wife, who is my power of attorney for financial management, simply will file the power of attorney with the PGT, and she will replace the public guardian and trustee. It's a little complicated. Now, if I don't have a power of attorney for property management, my partner or spouse or another relative can apply to the PGT to replace the PGT. A power of attorney without express authority to manage property can apply to replace the PGT. A trust company with the consent of the incapable person's partner or spouse can apply to replace the PGT. Where a person applies to the PGT, they must have a management plan. They must file a financial management plan, and I won't go through that in detail in terms of the process. It's somewhat complicated. Okay, are there any questions before I go on to talk about the obligations of guardians of property and powers of attorney for property? Any questions that any of you have?
Who can make the assessment
Who can make what assessment?
of capabilities?
In terms of making personal care decisions and admissions, personal care decisions and financial decisions, there is a regulation setting out who can do those assessments, and they're called assessors. And so doctors and a whole pile of other people and social workers and people with training. Now there's also an evaluator, because the law has to be dumb and complex. And evaluators evaluate whether you can make decisions about going into hospital or going into a long-term care home. And there's another regulation that sets out their qualifications. Okay? Most healthcare professionals, I don't remember because I'm old. You know, I started this morning, and when I started this morning, I had 7 functioning neurons. And now I only have 4 left. I think I have sundowner syndrome. I take no responsibility for any statement made after about 3 o'clock in the afternoon. So I'm not sure if healthcare professionals automatically, I think some do for capacity for personal care, but I forget. Okay. Now there's another question at the back. Yes?
My brother was my dad's power.
Sorry?
My brother was my dad's power of attorney.
For property or care? Property.
Did something have to get signed, like when he started acting as power of attorney, like to sign checks and...
Well, if it was a continuing power of attorney, then as soon as it's signed, it gave him authority. If it was a power of attorney that only came...
1999.
Well, I don't know if it was a continuing power of attorney under the Substitute Decisions Act. It came into force on April 3rd, 1995. So I don't know what...
Okay.
Right?
So what's the continuing one?
Sorry?
If it's a continuing one, then both could be doing things at the same time?
That's correct. If it was a power of attorney which said it only comes into force upon a finding of incapacity, then only when there was a finding of incapacity. And so I can't tell. All right. Any other questions that any of you have before I go on? All right. People think that if they are a power of attorney for property management, it's like winning lottery for life. I've hit the jackpot, right? One of the major problems in this area is that when you go to a lawyer to get one of these signed or filled out, they might tell you when you make a power of attorney for property management, the significance of that. What they don't do is explain to you, if you choose to be a power of attorney for property, there are very onerous legal obligations imposed upon you. A guardian of property and a power of attorney for property management is a fiduciary. They owe a fiduciary duty to act exclusively in the best interest of the incapable person. They have to justify each and every expenditure that they make from the incapable person's assets. Okay. Financial decisions must be consistent with the personal care needs of the incapable person. So the first obligation is to meet the personal care needs of the incapable person. No, no, no. Mom loves kibble. Mom cannot get enough kibble. Mom doesn't want $6,000 hearing aids. Mom doesn't want a wheelchair. She likes being, you know, a handcuff to the cement block in the basement. Because every penny I don't spend on Mom now, I get under the will. Again, once this legislation was wrapped in the terms of patient rights, it doesn't matter what it in fact did. It's the power of rights rhetoric. Okay, so all financial decisions must be consistent. Section 37 requires expenditures to be made that are necessary for the person's education, support, and care, the education, support, and care of the person's dependents, and satisfying the person's other legal obligations. There are very stringent obligations imposed on gifts, loans, and donations. No, Mom wanted me to have a new boat. No, she did. She did. And she loves kibble. Can't get enough kibble. To the extent possible, guardians must explain to the incapable person the impact of the guardianship and encourage his or her participation. Okay. Guardians must encourage a regular contact with supportive family and friends and must consult with them. I have been told on a number of occasions, people say, I'm the power of attorney, right? And I forbid you, the nursing home, for allowing my scum-sucking brother to visit Mom. Well, A, chances are Mom is capable of consenting to that. It's not a treatment decision. It's a personal assistance service. It's an activity of daily living. Chances are she is capable of consenting who she wants to visit her, so I don't really care about the power of attorney. And the second problem is, violates the act. But people have this idea that if they're power of attorney, they get to do whatever the hell they want. And that's not what, okay. Now, if you do not take a penny for serving as a power of attorney for property, you must meet the standard of care of a reasonable person in managing their own financial affairs. So if you choose to be a power of attorney and you don't know anything about managing money and you make bad decisions, like buy the Briac shares that I'm selling at the end of the session, I'll throw in my Lehman Brothers shares. You know, I was tempted when Lehman Brothers was going down the toilet. They paid the CEO $37,000 an hour. I was willing to run that company into the ground for only $14,000 an hour. But it's a good thing I'm not a cynical or bitter or jaded person. No, not moi. Okay, if you take 1 penny for managing the money, you must meet the standard of care of a reasonable financial manager. How many people are aware of that? How many people are told that when they agree to be a power of attorney for property management? Now, the courts aren't going to care if you charge Mom $50 a week for food and rent and housing. They are going to care that when you become the power of attorney for property management, Mom's stock portfolio is worth $400,000. 6 months later, when she's dead, it's worth $1.42. They are going to care. They are going to care. You are personally liable for any breaches of these duties. Civilly liable. That's the last of your problems, right? Stealing from your mother is still stealing. I would like to see far more criminal charges brought. Stealing from your incapable, or stealing from mom is not really a criminal offense. Not really stealing. Anyway, she loves kibble. Okay. Okay. Guardians must act in accordance with the management plan and must keep proper accounts of all transactions. Okay, let's say you're the power of attorney for mom. And let's say you're able to fool everybody while she's alive. Hey, I'm home free. Wrong. On death, the beneficiaries under the will are going to demand an accounting. It's called passing of accounts. And they are going to require you to justify each and every expenditure that you made from her funds. Because you can only spend money, right, as a fiduciary, exclusively in her best interest. How many people just are not, this is not explained. This is not, unfortunately, explained. Okay. I won't go. I want to talk about accountability, fraud, and endless litigation. We're beginning to see some civil suits brought for financial abuse of seniors. We're beginning to see those civil suits. We will see a lot more. The banks have been burned on a number of occasions by people purporting to be the power of attorney and just signing mom's name. Now, if mom is incapable, chances are, has been incapable for 20 years, the power of attorney that she was supposed to have signed last week is unlikely to be valid. So some banks are saying, I will only honor a power of attorney on one of our forms because they have been burnt and held liable by people defrauding them. Alcombrec estate in Alcombrec, that's where there was a power of attorney for mom. Mom dies, the beneficiaries under the will said, where's the beef? And the court will grant a passing of accounts and will require that accounting. Fiacco and Lombardi. Okay, so there's a dispute between the family. Long, protracted litigation costing tens of thousands of dollars. The court makes a decision that the power of attorney for property management will be A and B. And they issue an order to two of the other relatives, requiring them to do some stuff. The relatives refuse. They have to go to court to get the order enforced. And the court said an incapable person's assets are not to be treated as an ATM bank machine to fund needless litigation generated by stubborn and greedy relatives, and made the stubborn and greedy relatives pay all of the costs. About time. That's the least of the problems. I would like to see more criminal charges brought. Right? The prospect, the likelihood of getting caught is small. It involves civil litigation. It takes forever. My view, if you steal from your mother, it's theft. Charge your bugger under the criminal code and send him to Club Fed, where I hope and pray he's locked in a small room with a large bunkie who doesn't believe in alternate means of dispute resolution, where they play the parliamentary channel 24 hours a day, because I believe in cruel and unusual punishment. All right. Are there any?
We have to be out of here by 8:45.
Oh, we'll be long gone by 8:45. Okay. Okay. And you believe the lawyer? Sorry, just okay. Okay. Any questions before I go through my 6-hour conclusion? No. Yes.
So if you have a beneficiary, or if your beneficiaries are charitable institutions,
They're going to demand an accounting.
and they're going to demand to see a copy of the will,
If they're a beneficiary and a certain portion of the will has been left to them, they're entitled to a copy of the will. And they are entitled, like they know the person well. That person said they were going to leave them X zillions of dollars. Push comes to shove. They die. There's no money. They say, where's the beef? So any beneficiary can demand.
So you have to go to court to get it.
Sorry?
You have to go to court to get that passing accounts.
It's not a very complicated. It's almost automatic. It's almost automatic. Your power of attorney for property management or a guardian, and there's a demand for a passing of the accounts, you will get it. Again, it's not as any kind of court is some costs and hassle. But every one of these cases, they they ordered a passing of accounts. Every one of them. Yeah.
So I know some charities have a policy with that they will never challenge a will, but certainly a lot don't have such policies and they're not really enforced. The last thing I'd ever want is for a charity to kind of challenge it. Like, are you able to kind of put certain beneficiaries that's like, if you challenge this will, you ain't getting a penny?
Sorry?
Could you put in your will to certain beneficiaries like charities that if you challenge
Okay.
the will?
I don't, okay, I'm not an expert on wills. I don't know the legal force saying is if you challenge the will, you'll get nothing. I don't know if those are valid because I don't teach wills. But I wouldn't see any reason why any beneficiary under the will is not entitled to ensure that they get what they are legally entitled to. Now I can understand that a charity may not want to be involved in litigation, but at the end of the day, that was the money of the deceased, and it was the deceased's wish where the money went. And so I have a fairly strong views about people who steal from their relatives, particularly elderly relatives. Yes.
I have one quick question. If mom says, I have a shoebox full of money, blah, 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 but doesn't get around to making a will and tells her kids, use it for this, this, and this, is there any legalities if the kids actually do that without informing the local, the public trustee? If mom has met with the family and she says, I want you to have my watch, I want you to have my ring, I want you to have my dish collection, and the family is all copacetic, no problem. I think there's one of those families in Canada. I think there's one, maybe half of a family. So, sure, sometimes that happens. When my mother died, I was the executor
Will be turned off in 25 minutes.
under the will, and I went to the bank with a death certificate and the will. He said, oh no, you need to probate the will. And I said, no, I don't. And I didn't probate the will. I didn't have to. So again, if everything is acrimonious, it all goes swimmingly. Sometimes, in many cases, it's not acrimonious.
I had one of those rare moments where everybody was just...
Great.
But there was no will, there was no letter left, it was just a sudden death, and everybody just got together and said, okay, this is what...
Great. Great. Yes. Yes.
In the case that somebody was talking about where if you have a family member who's squandering the money as the power of attorney for management of property before the person actually passes, and then you get to the passing of accounts.
Okay, so you probably have to go to court. You can also apply to the court to become a court-appointed guardian of property. You're in law land. You can make a complaint to the office of the PGT if you have a certificate of incapacity and can convince them to investigate. So there are remedies.
But to get to that point where they decide there's no money left, right? You come to the passing of accounts, there's no money left,
right?
And people are saying, okay, well, we want to see where all this money's going to. Can that person who is now just squandered the money just file bankruptcy? And just yeah, they can, but they've still committed the federal criminal offense of theft. They've stolen the money, and so they should be charged criminally. Yeah, I mean, if you have a choice to be hit by a guy on day parole driving a stolen car who lives at no fixed address, or by a guy, Warren Buffett, driving a car, choose to be hit by Warren Buffett because you can't get blood from a stone, right? And so that may well happen. If the money's all gone, the money's all gone. Yes, and then I'm moving on. Yep. Sorry, I can only hear one.
The banks say, no, we don't recognize your power of attorney, sorry, we've been burned before. What's the person's recourse?
You can whine. You can whine a lot. You can withdraw. You can threaten to withdraw your bank account of $1.80. You can complain to the bank ombudsman 15 or 16 years later. So at a certain point, it may not be worthwhile yelling at people and telling them. But
you know, you may ultimately have to get the power of attorney that the bank uses. It may not be worth the hassle that it's going to take.
I'm assuming the person's not capable when you present your power of attorney to manage.
I'm sure that if you pushed long and hard enough, you could get them to accept it. If the person's not capable anymore, you can't forge their name. But I don't want to go down that route. I think diplomacy, advanced diplomacy, cajoling, bluffing, explaining, etc. They may require you, fine, you don't have to give us a power of attorney, but you have to sign an indemnity that if things go bad, you'll pay them back. So there are remedies. I don't want to get into that level of detail. It's way too technical, I think. Yeah?
Does power of attorney have any more validity if it's done with a lawyer or a banker or scrawled on a piece of paper?
In order under the Act to be valid, it has to be with 2 witnesses. So powers of attorney aren't expensive to get created. They don't charge a lot to create a power of attorney. There's probably power of attorney forms you can get from your bank and other financial institutions. I would also go and see if you can get a power of attorney form, I know you can, from the website of the Consent and Capacity Board or the PGT. So there are those forms available. The more likely it is that it's going to go boom in the night, the more acrimonious the family, the more it makes sense to have it formalized and pay the money to get a power of attorney. I don't know how much they cost. They're not very expensive. They're not very expensive. Yes, last question, and then I'm going to conclude and let you guys escape.
Did you tell us that you would give us a website where we can get this information?
I'll give you the website that has my PowerPoints on it.
And you can access this?
Yeah, okay. Okay, if you look up the word computer dolt, there I am, knuckles on ground, with my non-mechanical pencil in hand. So I won't put this on the website, wherever that is.
So you're talking about the PowerPoint?
Yeah,
Yes,
Nicole will.
PowerPoint will be on Classes Without Limits, Quiz's website on. They said 2 weeks.
Okay.
Monday.
Okay, I've got to conclude. All right, and let you guys escape because they're going to throw us out of here anyway. All right. The law gives you the right to dictate how you want to be, what treatment decisions you want when you are no longer capable of making those decisions for yourself. What kind of financial decisions you want to be made when you are no longer capable. And it allows you to determine who you want to make those decisions. Okay? Think long and hard about these issues in terms of who you want to appoint as your power of attorney. Use your head, not your heart. You know? And so, yes, your son with a gambling addiction will feel slighted if he is not made a co-power of attorney for property management. But the history of these things and the litigation surrounding these things are such that you have to make those decisions that are going to result in the treatment you want, the financial decisions you want, and the people making those decisions to be people who you can trust will carry out your wishes. Now, the law does provide mechanisms for resolving challenges and uncertainties. But as we've seen, they're slow, they're expensive, and they're convoluted. And so, because the law gives you the power, you can control your own destiny by carefully addressing these issues. So you can develop an advanced directive if you want on a piece of paper. You explain it to your family. You sit them down and tell them what you want to happen. You give them a copy. You give it to your lawyer. You give it to your family doctor. Now, if you want more control, get a power of attorney. And think about the decisions you want, who you want to make the decision. Understand that if you name 2 people equally and they disagree, they won't make the decisions. By carefully addressing these issues, providing clear and simple instructions, documenting your decisions, and communicating them to your family physician and lawyer. And taking control of your destiny makes a lot of sense in this day and age when the law doesn't really provide readily available means of resolving a conflict. Thank you all very, very much. Thank you. Thank you.